Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, coming to you with my pearl-handle pistol cufflinks, granted to be so graciously by our content genius, Michael Rivers, and creator of our channel. Give some love to that guy, because he is awesome. Anyway, today we are reacting to, this is a Melly update. But before we get to the Melly update, guess what? This episode is brought to you by eForms.com. That's eForms.com. If you need a business agreement, you need a power of attorney, you need any kind of form, no matter where you are, no matter what state you're in, go to eForms.com. And don't pay a guy like me. Why would you do that? I would just go to eForms.com and charge you a shit ton of money. Cut a guy like me out of it and go to eForms.com. They've got whatever you need. So, today we're reacting to Melly. Where is Melly? Why hasn't he had his trial yet? I want to know what's going on with Melly. Well, here's what's going on with Melly. Melly was supposed to have his trial last July, right? And the defense filed a motion to take the death penalty off the table. Why'd they do that? They did that because they said that the state did not comply with the notice requirement. You have to notify the defense 45 days before the hearing with the intent to seek the death penalty. Well, the state did that, but then they filed a superseding indictment. The superseding indictment is an indictment that contains some different information than the one before, and it replaces the one. In other words, superseding, right? Well, there's a question as to whether or not that superseding indictment required new notice. So the judge said you didn't comply with it, death penalty is off the table. So then what does the state do? The state has the right then to file what they call an interlocutory appeal. That means they file a notice of appeal, they argue this to the Supreme Court, or no, to the Court of Appeals, rather. So let me just read you basically the first paragraph of the opinion. In 2019, the defendant was indicted for 2 counts of first-degree murder with a firearm. The state filed a timely notice of intent to seek a death penalty, which included aggravating factors that the state would rely on while seeking the death penalty. And that aggravating factor was what? Gang affiliation. And I kind of don't think that they can approve that this is for the benefit of a gang. But that's another story altogether. But in 2022, a superseding indictment added sentencing enhancement for benefiting, promoting, or furthering the interests of a criminal gang, like I just said. Since the state did not file another notice of intent to seek the death penalty after filing the superseding indictment, the trial court granted the defendant's motion to preclude the state from seeking the death penalty. And the state filed a writ of prohibition, that's a way you ask the Court of Appeals to do something, arguing that the trial court exceeded their authority. And so the Court of Appeals says, we agree. Now, I'm not going to read the whole opinion to you, obviously, but I'll read you their summary. In summary, we find that the trial court exceeded its authority by precluding the state from seeking the death penalty. The state complied with the statute and rule requiring notice within 45 days of arraignment. We grant the writ of prohibition, remanded the trial court, and direct the trial court to allow the state to proceed in seeking the death penalty. So the Court of Appeals has reinstated the death penalty. Guess what Melly's team is going to do next? They are going to go up to the Supremes. So if you're looking for a trial date anytime soon with Melly, it's going to be a while. Now, and this is important because it is the death penalty is on the table here. So just to give you kind of a brief summary of what the different courts are, you have the district court level. That's where all the trials happen. And then anything that arises out of that can be reviewed by the Court of Appeals. And generally it's anything a judge does, anything that happens in a trial, those kind of things. And the highest court in any state is the Supreme Court. So you've got the District Court, Court of Appeals, and Supreme Court. So the Court of Appeals is reviewed by the Supreme Court. Now the Supreme Court is discretionary, has discretionary review. So let's just say they don't take this case up. So Melly's team will file what they call a writ of certiorari. Means that they are making application to the Supreme Court to review the state court's decision. Now, one of the things that the Court of Appeals did in this case, in addition, we certify the following to the Supreme Court as a question of great public importance. Whether the filing of a superseding indictment, which adds only a statutory sentencing enhancement, requires renotice of an already timely filed notice of intent to seek the death penalty. So they're asking the Court of Appeals to answer that, or the Supreme Court to answer that question. So Melly's team is going to file a writ of certiorari, and if they don't take the case up, then then the lower court's ruling will stand, and that death penalty enhancement is on the table and is no longer thrown out, and he's looking at the death penalty. But my guess is that the Supremes are going to take this up because the Court of Appeals has asked them specifically on a matter of public importance to address that issue. So this has just been a quick Melly update. So the death penalty right now is back on the table, but we'll have to wait to see what the arguments at the Supreme Court level would entail. So it's really just as a fairly simple issue, whether, because they filed a notice before, but then you get a superseding indictment, which means you have to be rearranged on that new indictment. And so the issue is, does that prior notice is that still good, or do they have to renotice because there's a superseding indictment? The Court of Appeals has said you don't need to renotice. I know it's kind of a boring legal thing, but it's super important. And it's super important because it's somebody's life that's on the line here. So we'll see you next time here on Criminal Lawyer Reacts. Make sure you like, subscribe, and follow the merch. The merch is great for Christmas or Hanukkah. How many nights do you have? Like 8 crazy nights in Hanukkah? You could have 8 crazy gifts from our bonfire. So order them now before they're gone. See you next time on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please just at my God.